DVD, TV screen, etc.? No. Does the case involve complex, novel, unusual points of law? No. It's a straightforward case. Does the prosecutor intend to produce experts? At this point in time, there is no offer of that, and the answer is no. That's all for the prosecution.
So the answer is yes. There's legal counsel. Is the counsel, number 2, is the counsel engaged by the court or by the accused person? Number 6, does the accused intend to raise any statutory or other defense? Yes. You have 1. Yes, just the accused person.
Is the accused represented by legal consent? Yes. Is the defense counsel engaged by the court or by the accused person? By the court. Number 3, is the accused in custody or out on court or on bond or bail? Bail granted. They are theoreticals. Yes. No. She's not out. The third, yes. Yes, for the third accused. Number 4, if the accused is in custody. Number 8, are all the defense witnesses readily available for the trial? Yes. Number 9, do any of the witnesses have special needs? No. Number 10, is any of the witnesses a minor? That is no. Number 11, does DVD clear TV screen in the courtroom? The answer is no. Does the defense wish to raise a complex, novel, hence considered alternative dispute resolution as an appropriate method of disposal of this case? The answer is no. Number 22, has the defense considered plea bargaining? The answer is no. And number 20.
Kulingana na ushahidi wa wale majirani wako, wewe ndio ulikuwa na marehemu wakati ambapo alipopigwa kisu. Ndio ushahidi wa daktari ambaye alikuja kueleza kwamba marehemu alikuwa amepigwa kwa kisu.
I noted that the deceased developed some complications leading to infection from that surgery.
Kwa tunaelezea kwamba ile marehemu aliweza kupata infection kwa sababu ya ile jeraha ambayo alikuwa amepata kwa kifua ya kudungwa. Naeleza kote vile utapata kutetea na kama ukita shahidi yoyote. And one on the list, it's year 6 of 2019, but I will come up. Already the forum is as before. My lady, and before we take the plea, I have noted that on the 16th of September 2019, the presiding judge of the Criminal Division, 16th of September 2019, the presiding judge of the Criminal Division, Lady Justice Lesit, ordered that the DCI
investigators, prosecutors, defense, and I emphasize defense, and victims should desist from addressing the media on the investigations and evidence alleged to exist in this case. My lady, hardly 8 days after that, during the burial or the final rites of Mr. Cohen, that is on the 24th of September 2019, the accused, in the presence of the defense counsels, the two of them, addressed the public on issues or evidence alleged to exist in this case. The accused went ahead and attempted to threaten her co-conspirators and witnesses, saying that their days are numbered. Co-conspirators, and that is my reference to whoever she was referring to. I am referring to them as her co-conspirators and potential witnesses, because by the time we present our case, we will differentiate them, saying that their days are numbered. My lady, this is contempt of the court order, taking total disregard of the orders given on the 16th of September 2019. All parties were present, that is the two defense counsels and the accused, were present when the order was given by Lady Justice Lesit. In view of this, my lady, these orders having not been vacated, I do pray that this honorable court does find the accused and her counsels in contempt of that order. We are in a position to even avail the clip and even to provide witnesses who were there on that material time. My lady, this act was not only in contempt, but created public disturbance and outrage. I therefore ask this court to find the counsels in contempt of the order before even plea is taken. That is all.
My lady, so that yes, ma'am. Yes, my lady, so that my learned senior can be able to also respond to both issues, including what I'm going to ask. My lady, it has been brought to my attention that learned counsel, Mr. Murgor, who is now senior counsel, we must appreciate, we must congratulate, was appointed as a public prosecutor on the 16th day of January 2019 by Gazette Notice number 350. Was appointed as a public prosecutor for 2 years from the 16th day of January 2019, via Gazette Notice number 350, from 2019, January 16th. 16th of January 2019, yes, this year, for a period of 2 years. So we are looking until 2021, probably. And at this particular moment, he also now wants to be the, or he is the lawyer for the accused person in this case. Him being a public prosecutor, isn't this then an issue of conflict of interest? Can he work for the government at this particular moment and also work for the defense? So that the issue of representation for the accused person does not come to haunt us at a later date, that needs to be clarified. And I'd like to inform the court that I have tried to look for any gazette notice showing that he is no longer prosecutor, and I've not come across any. If he has any, probably he might be able to again give the court. Then that might disqualify him or must disqualify him from proceeding in this matter. And if the court then finds that he can be disqualified, then the court can now appoint counsel for the accused person.
Anyone else? I'm asking because there's several of us. I want to respond to. Thank you. I start with the first application. The first application is a very serious, it raises very serious issues which can only be brought by way of a formal application. The issue of contempt is a very serious one. It is an accusation which, if proved, can lead to penal sanction, which means my colleague, Ms. Moniki, and when I say my colleague, I don't mean a fellow prosecutor, I mean fellow counsel, should know that she should lay that charge of contempt of court by way of affidavit, produce the clip in question, and show that in fact either the accused or counsel commented on the merits of the investigation. What she has said is absolute lies from the bar, false, and is intended to divert attention from the real purpose of today's hearing, which is a plea and a bail application. Luckily, we recorded the proceedings of the day. The first person who spoke is the brother of the deceased. The second person who spoke was an ambassador. The third person was the widow. And then two politicians whose role we are yet to define in these proceedings. No one breached the court order. No one discussed investigations. What the accused did was the only thing that a widow could do in the circumstances. It mustn't be forgotten that Ms. Moniki and her team, 14 days after charging the accused, have not presented an iota of evidence to support their charge sheet. Not a shred of evidence. To this day, not a drop. So it is only in her mind who a co-conspirator is, who her witness is, who anybody else is, because in our case, there is no one who is a co-conspirator, because it is not in the evidence bundle, which she has never produced. It is not in any evidence that we have been shown, even by the investigating officers. I see Mr. Otieno here. He has never shown us anything in IO. So it is a figment of her own imagination that any lines were crossed. So for that, with great respect to her and my former office, which is almost bringing me to Mr. Mbete's issue, the proper way to do that is to file a formal application. We shall respond, and that issue of that contempt can be dealt with at any other time. It can be dealt with tomorrow, next week, or any other time. But to bring it up on her feet, without a recording, without an affidavit, her own or anybody else who imagined there was contempt, is to abuse the court process from the exalted position of the office of the Director of Public Prosecutions. So I urge the court to order her to quickly file her application, and it shall be responded to vigorously, because it is a whole lot. I will not say more than that. Let's come to the second one. First of all, and the other one is raised without notice to ourselves. So we are only responding as we hear it. Our view is it is meant to ambush and detract from the business of the day, and it's therefore a sideshow. The second issue has also been raised without the courtesy of letting me know. It is a matter of fact that in 1987 I was a public prosecutor in that office. I resigned many years later. I returned as the DPP in 2003 to 2005, and I left and more recently I was appointed. I normally carry the bundle around with me. I was appointed a public prosecutor by Gazette notice dated 16th January 2019. Gazette notice number 350. The date of the Gazette notice is 16th January 2019. After wasting, I did provide an undertaking to the DPP that I would not act against them directly or indirectly as long as I was a public prosecutor. And after wasting 2 months of my professional life, no work was given to me, and I found the professional opportunity cost too high to bear. And on 7th of March 2019, I resigned as a public prosecutor in a letter dated 16th January 2019. Sorry, it's not the other one. It is 7th March 2019. Yeah. And I resigned and I gave my reasons, which, out of respect to Nurdin Haji, my professional colleague, I will not read the contents of that letter of resignation. But I told him exactly why I found working for that office on their terms impossible. So, my learned friend says I am both a prosecutor and defense counsel. Nothing could be further from the truth. If he had asked me, I would have availed to him documents to show that I have resigned, and I would have pointed out to him that the revocation of a gazette notice is of no consequence. It is at my option. When I resign, or a person resigns, that is the end of that appointment. To suggest that that appointment will depend on Mr. Haji revoking his gazette notice would be to subject me to slavery and servitude, meaning I am then bonded, bound to work for the DPP and nobody else. Mr. Nurdin Haji is a gentleman. It is not his position that has been taken in this court. I probably do not blame Mr. Mbeta because he did not know better. He is entitled to ask the question, but he should have asked me first. But whatever the case, just like in the first application, Mr. Mbeta should have filed a formal application challenging my capacity to appear in these matters as a defense counsel, so that I would respond in writing. I mean, by way of affidavit. It is a further fact that they are all aware of that I even attend to the DPP's office in other matters as a defense counsel. More recently, in the Kimwarer and Aurora Dam case, where I have been to that office to pick up defense counsel material, 42 volumes of material. And they happily handed me those cartons and cartons of documents without telling me, but you're a prosecutor. So this is all a distraction, a waste of time, and an abuse of process. But on the issue of contempt, I want to go back. So I would request that the court orders my learned friend to file a formal application, that is Mr. Mbeta, and respond. That can be handled today, tomorrow. But neither issue should affect the issue of taking a plea or dealing with the bail application that we have filed. I go back, I'm reminded that I should go back to the issue of contempt. Your Honor, without going into the application for bail, I want to point out that we have filed a supplementary affidavit. Filed a supplementary affidavit, and it has a press cutting, which I wanted to point out to show you. Actually, the question of contempt lies elsewhere, and there's the old saying: when you point one finger, be careful, because 3-4 fingers point back at you. I'd like the court to turn to that press cutting that I have on page 19. You have it? Yes. On page 19, who really has been committing contempt, if at all we can call it so? It is George Kenoti, the director of CID. who, after the order was given, could not restrain himself. This gentleman loves publicity. And he gave an interview to a Dutch newspaper where he, at page 19 is the translation, where, by the way, the Dutch newspapers have continued writing in total disregard of the newspapers, quoting the Cohens and the investigators. But on page 19, under the title, third from below, under request bail, she had, this is talking about the accused, she had previously requested to be released on bail for the time being in order to protect her possessions, in their own words, for fear that the police are also after the assets. Research leader George Kinoti, it means, translated it means investigator, already described this as ridiculous, but at the same time indicated that the detained woman appropriated part of the inheritance. And then they quote him, "Somebody found guilty of murder can never inherit the murdered person," he explained Kenyan law. But apart from that, somebody who has his partner murdered and then dumps it in a septic tank should never succeed at all, says Kinoti. This is after the order. You can see that the person who has lost control of his mouth, who no longer has any regard for court orders, is the DCI of the Republic of Kenya. And it also shows that the real issue here of denying our client bail is about the DCI seeking to hand over the matrimonial home of the accused to the gentleman here called Bernard Cohen and his sister Gabri Van Straten.
Yes,
I am actually pointing out that the real issue here. No, I was talking about content, just content, the people who are guilty. And then secondly, there is a state council called J.V. Owiti, isn't it?
He's not around.
He's not around, but he's a state council.
We don't know someone like that.
There is a state council called J.V. Otieno who was here in the in the proceedings before Justice Kariuki. Yes, before Justice Kariuki. And 2 days ago, he decided he was an academic and he wrote a treatise on a murderer cannot inherit from the deceased whom he or she killed. This is published on social media, and at paragraph 1, paragraph 2, paragraph 3, paragraph 4, paragraph 5, he liberally refers to this case and the Cohens. And finally, I just go to the last paragraph. I am persuaded with the second possibility, and I think it will carry the day. Sarah may end up losing everything from the matrimonial property and or Cohen's estate. I rest. What am I saying? It is the prosecution. He is a prosecutor. I am not a prosecutor. He is the prosecutor. They are urging their case in the media. They are urging to the prejudice of our client on the merits of the case. So it is they who are out of control. So I am requesting, therefore I conclude by saying the issue of content, if at all, should be canvassed by way of a formal application to which we shall respond. The issue of my capacity to be both a prosecutor or and a defense counsel, I am happy to entertain or respond to that application, including giving an affidavit on how many times I've met Nurdin Haji as a defense counsel on this and other or not on this matter but on other matters, and then it shall be attended to. In the meantime, Your Ladyship, before Her Ladyship Justice Jessie Lesit on the 16th of September, is it 16th or 18th? I'm not sure. This looks like 18th. 16th, eh? Yes, on the 16th of September, the court listened to the parties, found that the accused had still not been subjected to a mental assessment on fitness to stand trial, and ordered, we were made an application for bail orally. We were ordered to file and serve the application for bail. We did so on the same day, filed it and served it. Yesterday, we were served with a replying affidavit from the so-called victims, represented by my learned friend, Mr. Mbeta. 2 affidavits.
My lady,
In
with all
ready-
due respect to my learned friend, he's supposed to be responding to our 2 main issues that canvassed it.
I was actually finishing by saying what is for today. I'm not canvassing it. We were served with 2 affidavits by the so-called victims by my learned friend Mr. Mbeta yesterday. We have filed a supplementary affidavit today, as soon as our client was in the court building. We were able to swear her affidavit. And I would like to say the prosecution have not filed any replying affidavit in opposition to our application. I'm actually contextualizing the other 2 side shows. It is to mask the fact that they have not filed any replying affidavit in opposition to the bail application. I would therefore request that we proceed to take the plea. I believe the certificate of fitness is on the file now, and then we discuss or we argue the bail application. All those other matters can be dealt with as soon as the court so directs. Thank you.
Yes, my lady, definitely. My lady, we need to differentiate between the evidence allegedly, the evidence in this murder trial and issues of succession. What my senior learned friend has attempted to allude to contempt by either the DCI or Mr. J.V. Owiti are issues in regard to succession. And the issues of succession will be dealt with in a separate court, and there was no gag order in regard to the issues of succession. So we need to differentiate that. My lady, I did indicate that we are willing to provide the said recording, and we can file a formal application with affidavits even for witnesses who were present, who heard what the accused said, and the defense counsels. My lady, and I needed to bring this to the court's attention before plea is taken, because if the court finds both the accused and the defense in contempt of the court can proceed to sentence, and thereafter the defense counsel will not even be in a position to represent the accused persons. So I am praying that we be given an opportunity to put in our formal application and all the evidence, and the recording is also in public domain. And my lady, in regard to the issues raised by Mr. Cliff Mbeta, I have seen the Gazette note.
He can file.
We are praying that we be allowed to file a formal application with affidavits of contempt, yes, on the issues of contempt, and even affidavits from persons who are also present at the scene. Yes. because what is in contention here is the order dated 16 of September 2019, and not on issues of taxation. In regard to Mr. Murgo's representation, I have seen the special gazettement on his appointment. I am requesting for time to confirm whether the said was revoked or any other instructions in regard to this matter. The said gazette notice was revoked. Yes, the gazette notice appointing him as a public prosecutor, whether the same was revoked. So I'm requesting time, and the same shall be done also in the course of filing a formal application in regard to the issues of contempt of court. And my lady, as I sit, I'll also be praying that this court does again confirm or request all parties again to comply with the order of 16 September 2019, even after today's proceedings. That is all. Oh, sorry, my lady, there's one issue on the affidavits on bail. My lady, the reason why the prosecution has not filed its affidavit, we have written a letter to the Witness Protection Services or agency requesting to have some of our witness placed under protection. The communication and the content of the letter again is confidential, so as not to reveal who we have requested. And my lady, based on that, we will then be able to put our affidavit, and we intend to annex their statements, redacted statements, to confirm that the accused or through her agents have been interfering with the witnesses. So without that, without them having first been placed under protection, we will not be in a position to prove that, which is very vital to our role. Because we don't have OB reports confirming the same. So we are praying that the plea be deferred until the issues of contempt and representation are dealt with. And in the same time, we are given time to have our witnesses under protection who are key and vital to prove compelling reasons as to why the accused person should not be released on bail or bond. That is all.
Yes. My lady, I've seen a letter by Mr. Morgor, Senior Counsel, on 7th of March 2019, resigning as a public prosecutor.
Perhaps I should tell my learned friend I'm not yet a senior counsel, but I'm senior.
You can see my
senior to him.
You can see my prayer is good.
Thank you.
I'm wishing you well, my brother. Yes, and my lady, the question would be then, is this letter by itself conclusive that is no longer prosecutor? Can a letter for resignation revoke a gazette notice? When counsel says that waiting for this revocation would make him to be a slave, with due respect, I think that is it's mischievous and does not have any tenability in law. And that position has got a remedy if Mr. Haji, the DPP, has refused to regazette him or has not done so. Then these courts have a judicial revision section. he can walk there and go for mandamus. If that still is the position, he then feels aggrieved, and he is aggrieved at this particular moment, then he needs to go to the JR division. But still, that question of who he is in this court today, apart from being a defense counsel in this matter, we know him as a public prosecutor. That one out there again is an issue. And it is important because why? In a murder trial, representation is everything. It is everything. So let us not take it lightly, like he is doing. Let him not say it's a sideshow, because this is a key issue. We don't want to remain with egg on our face. This is a preliminary issue that must be decided and canvassed, so that none of us is embarrassed at the end of the day. Not him, not any of us. This position must be clarified before he even takes plea for the client, because if the client takes plea at this particular moment without this issue, then is she represented? Then aren't we now going against the law? It's a serious issue. You cannot, please.
I
cannot
think
respond.
I will leave. Your Ladyship.
Cannot.
Yes. No, I'm not responding to Mr. Mbete. I'm responding to Ms. Moniki. She has made a new application. Yes, she has made a new application. She has now conceded that she will file a contempt application.
It's not a new application, my lady. It's what he requested of us, and we are confirming that we will then file a formal application. So that is not a new application. I think he needs to be very clear.
Your Ladyship, if I may explain.
I'll give you a leave, Mr. Mungu.
Yes.
But just let's not go back on the
I'm not going back on this. Your
Be brief on what you think has been doing as a minister.
Your Ladyship, thank you. Ms. Moniki started by saying they have committed contempt, sentence them for contempt. Right away, without defending themselves or anything. Just find it as a matter of fact. Now she has accepted that she will file a formal application. So effectively, she has abandoned the oral application. That is gracious on her part. On the part of whether or not I am a public prosecutor, she has stated in no uncertain terms that she needs to seek some instructions on that matter. And I think the final position on whether or not I am will come from Nurdin Haji, and we'll expect his affidavit in that regard. So what Ombete is asking, they are good questions because he's in the dark, but it is a matter that will come from the DPP's office. So what am I saying? Even that now should come in the form of a formal application, and we shall respond.
My lady, just to clarify, we just said I need to confirm whether he has been revoked, whether the Gazette notice has been revoked. Those are the only instructions I need. The DPP will not file any affidavit. It is I to go and seek or to find out whether there has been a revocation of that Gazette notice.
So how she does it, I will leave it to her. I don't wish to. I know Mr. Haji does not like coming to court, so we'll leave it there. I don't want
My
to say
lady,
more.
with all due respect to Mr. Moko, he has he has adversely mentioned, yes, my lady, protect the officers. He has adversely mentioned the DCI's name. He's not going to the DPP. Yes, thank you. Thank you.
So the final part, which is most important, her position has now mutated and she has made a new application. A new application, to which I am now responding, is that can the plea be deferred? She was now explaining why she hasn't done her affidavit, witness protection and all these other things. And so she's saying, can the plea be deferred to enable her to do all that. So I want
No,
to
my lady, there, and
Unless I will
Mr.
get a
Murgo
chance.
is not getting to a point that I will need the court's intervention. I say that the plea be deferred for us to ensure representation and content, that those two issues are dealt with. And please, my lady, I'm praying that Mr. Murgo, being an officer of this court, does respect everyone in this court and the proceedings of this court, and he needs to be truthful.
You understood where she's coming?
I don't take orders from her, but I was saying,
That is true, but
yes.
you understood where she's coming from?
If she hears my next, what I want to tell the court, she will understand what I'm saying. I am saying it started out with contempt, then it became capacity, and then in her reply, she now said, we're going to do all that, but now do not take the plea. That is the part I believe I have a right to reply to, which is why.
You know, from where I stand and from where I sit,
Yes.
there are times when you're called upon to really have that privilege, because the nature of where you are studying and where she is that heated.
There's no heat, Your Lordship, on my side at least.
Let me tell you how I understand her.
Yes.
Okay?
Yes.
And
May I
first
sit
you
down?
understand her.
Yeah.
I'm understanding her to say the request for deferral of the taking is we have to confirm your position, whether as a public prosecutor and whether you are
Yes.
That bit is the one I want to reply to. Yes. Because it wasn't put out in front. In the front, she said contempt and capacity. So I am now responding to the issue whether plea can be deferred in order for her to file her applications. I would like to point out that the record will show that the accused has been in custody for 30 days from the date she was arrested.
My lady, aren't
I
there
am-
new issues? He's just supposed to be talking about representation.
I'm not asking for bail.
Those are new issues that she's been in custody for those days. We'll need to respond to that. The question is he rightful in court as a defense counsel? Can he represent her? Does he have audience? And that's what we are saying. Can this issue first we be given time to address this issue? That's all he needs to respond to. And without him giving us any proof for us to, so that we may not seek more time and deal with this issue right now, it's in the best interest that all of us be given time to respond to that. Or he is given time to
I'm
bring
trying to
evidence.
answer that. Your Ladyship, please, if I may just, not too big, if you just hear my argument. I'm not applying for bail in that sense, which is what she thinks I'm doing. This case is not about me, and it is certainly not about her. It is about this lady here. It is her whose rights we are talking about. So, I am saying, she has already been in custody for 30 days. And I'm now coming to the issue of, if they want to have those other matters dealt with before, they should be mindful of the fact that she has been denied her liberty for 30 days. Initially, for mental assessment, which is not her problem, it is the problem of the state. Then, by reason of the fact that it was the vacation and so on and so forth. So I am now coming to the fact that should they wish to have those other matters canvassed, first, I ask the court to ask them to file their contempt application in the next 2 hours, and so that we come back at 2:30 to deal with those issues, so that the matter of the constitutional rights of this lady here are dealt with as soon as possible. I am not the only advocate in Kenya. I have been in these proceedings several times without any objection from my sister, Ms. Waniki, my learned sister, not my prosecution sister. My learned sister, as advocates I refer to her. I am saying we have been here, no one has objected, and I'm just saying let's not forget we are here because of the accused. So if we can deal with those applications within the, they can file their application this morning, we'll respond in the afternoon. I'm ready because my facts are clear, and we can deal with them as soon as possible. It is the accused that we are here for. It is her who needs to take her plea. It is her who needs her application dealt with. I may also say one more thing. After 30 days, issues of witness protection should have been dealt with. If at all there are such witnesses. We have never seen them.
Ms. Maliki, if this court were to, because I understood it to mean you need to confirm Mr. Mugo's position,
Yes.
and for that meaning you want to check whether the letter, taking your issue together with Mr. Peters, whether what is being representing or the letter of discrimination.
My lady,
How
yes.
long, if I were to allow you, how long will that take?
My lady, because we also need, and what is more important, even the burden also shifts to him to show whether he's been degazetted. We will need about next week. Come back next week to confirm. Today is Thursday. My lady, to confirm. Because we need to confirm whether he's been degazetted. And if he's not been degazetted, my lady, someone else can stand in for him. He doesn't need to appear on behalf of the accused person.
All right. Allow me to make a ruling in order to see what
Yes.
take time to make a ruling on the issues you can work between those issues are coming on the spot. I therefore defer taking the plea for this person that you choose the first. Okay. In the meantime, Ms. Maliki, that gives you enough time to consider to follow up the issues you are raising. That is the issue of the local opposition and the if you are able to give us this having made that the ruling on the issues of consent and your confirmation to the directed by the city. So it should be remanded and come back to October when you come back. But once the issue of representation is finished, Mr. Municipal, the will proceed.
Could we have timelines on filings when they have to file by their...
Can I move to the next item? We don't need an order to access our exhibits.